Hi, my name's Todd Smith. I'm a partner at Jet Probate. Today, I'm joined by Hallie Tessemdorf, another one of the attorneys that works with us at Jet Probate. Today, wanted to discuss some issues involved that usually when we're representing clients that are the executors and personal representatives of the probate estate, eventually they're going to run into the issues of the distribution. So we're kind of skipping past a lot of the stuff that happens in the early phases, where we're trying to pay off creditors and we're trying to marshal assets and determine what we're dealing with. At the end of the day, we may end up where there's just a bank account with a bunch of cash in it, and we read the will and we say these are the people that are going to get it. So once we get to that point, Hallie, how would you kind of organize your thoughts on what the first step is?
Yeah, we've gone through the process of gathering everything and we have a pot. I always kind of talk my clients through 3 steps. The first is we have to pay taxes and expenses. So when we're looking at what we can distribute, we need to make sure we've accounted for that. So that's maybe step 1 is how much do we need to make sure we have to pay taxes and expenses? The second then is looking at, all right, if we're going to make a distribution, do we have specific gifts? Or these are people who get a specific item or a specific cash gift. And those are going to come next. Those are going to be the next ones that get a distribution from an estate. And so we kind of make sure we know who those people are. And then the last bit is who are the remainder beneficiaries of the estate? Who gets 50%, 50%, or, a breakdown of the percentages. Those are the ways that we will make distributions. And I think there's some considerations we have before we actually give somebody a check, right?
When we're representing the personal representative or the executor, what I like to say often is, I'm here to protect you. And so a big part of the distribution proposal includes some way of making sure that we can do this with some finality. So what do we ask the other beneficiaries of this estate to do or to sign to get us that comfort level we need to tell our client, the personal representative, that we're done here? You don't have to worry about somebody suing you later.
Yeah. There's a couple of things that we want to make sure so that our clients are protected, and that's, as you say, our job. One of them is if they've received a notice of what the distribution will be, they have 30 days to challenge that. And if they don't within that time frame, then we know our client can make the distribution according to what we've decided. And the second is that we want to have them sign a release that says, what you've done during this administration, I agree with. I'm not going to come back later and say, I didn't know that you sold the house. I didn't know that this happened. So it's a way for them to say, here's what you're getting, and here I acknowledge what I'm getting, and I'm going to say, I sign off and I will not, I'm releasing you from liability for what you did.
Yeah, and it's interesting because there are some things that we have to acknowledge as the attorney representing the executor, and we need to point out to our executor, make sure they understand there are things that the beneficiaries are entitled to as a matter of course. The executor has a duty to provide an accounting. Right? So when we started this process, here's what the value of all the assets were. Now we're here and there's a bank account and it has less than what everything added up to before. So we have to provide a report where we show them this is what we spent it on. There were legal fees, there were taxes, there were accounting fees. What's your experience of getting to that end, and if we're dealing with beneficiaries and an executor that actually get along and trust each other, what are ways we can actually all help save some costs and make it so that the beneficiaries get more?
Yeah. We will try. I think one of the things that we emphasize is making sure that we're transparent. We want beneficiaries from the beginning to know what's going on the administration, at least in a way that makes it so when we get to the end, they don't have a million questions. And now we need to see statements from a year ago, which is more work, more time. It's just more difficult. So if we can have everybody on the same page along the way, it will save the estate money. It will save the personal representative time, and it'll save legal fees. So that's one of the best ways that we can do it. And the second, again, is just providing a very accurate version of what we have, where we started and where we are now, so that there's no question of why is this lower? Well, you can see there were expenses. The house had utilities. We had legal fees. We had taxes. Just being very open and clear. I think those are the best ways.
Yeah, and often, to your point about different kinds of gifts, someone that's just in the will as to receive $25,000, a specific amount, they're not going to care what expenses there were, so we don't need to get them to sign off on on waiving any kind of further accounting or anything. So we're really just dealing with the residual beneficiaries. Are there any other issues that you've found in dealing with this distribution proposal, getting to that final endpoint?
I think that really important one is that the personal representative keep good records throughout the administration, that they keep track of their time, that they put down what they did with accuracy and when they did it. And that way, at the end, if they want to take compensation, we aren't worried about recreating anything. We've got it here in paper. I think that another thing might be making sure that beneficiaries are aware of selling specific assets. I've had clients who at the end said, those shares that my parents had in Apple, they bought when they were original. It may not make logical sense, but if the beneficiary is aware of some of our steps that we're taking, it will at least answer questions rather than raise these red flags that we can't undo, or selling a house or selling something of sentimental value. I think, as you say, it's really important to know who our beneficiaries are, and if it's somebody who's a specific gift, be able to maybe have them receive their distribution as soon as possible so that they can be done and the personal representative doesn't continue to bear the liability for a long time over that beneficiary's rights. So
Right.
different steps we can take.
This is all good information that I think is a discussion that should be had with the executor right at the beginning, right? So we know the end, we have the end in mind, even when we're doing those initial stages of just marshaling assets and paying creditors. Well, I appreciate your time, Hallie.
Yeah. Thank you very much.